want to talk about a couple of things before we bring the jury out. First of all, the clerk is asking for some advice on how to publish the verdict. I'm sorry, that's not true. She knows to publish the verdict individually, of course, as to each defendant, but if counsel requests a polling of the jury, would counsel want them to be polled as to each individual verdict, or could they be polled as to the verdicts plural? And I don't know the answer to that. So, Mr. Will, do you have a suggestion?
I would request that they be polled individually with respect to the defendant. Is this your verdict with respect to Wayne Greenlaw? Is this your verdict with respect to Ray?
So as to each juror, ask it both ways.
Yes, but not each count, just each defendant.
As to that procedure, what is counsel for Wayne Greenlaw's position?
I don't have a problem with that, that's fine. I would think that would be the appropriate.
Right? Madam Clerk, are you comfortable with that then?
No problem.
Okay. Let's talk about after the verdict is published. We don't know the outcome of it, of course. Looking at different options, I just wanted to determine whether sentencing is appropriate today. I don't know what the state's looking at in terms of victim impact statements, et cetera. What is your recommendation, Mr. Will?
If it's as charged, I don't see any reason not to proceed. In
Would-
fact, even with some lesser than maybe appropriate to proceed.
Do you wish to have, is it just going to be a straight sentencing, or is there going to be testimony regarding sentencing, from your perspective?
I haven't talked to the family that far. I was going to wait and see what happened.
Well, I want you to talk to them now, because depending on what's involved, I may have the jury stay.
Okay.
And but if there's going to be a lengthy sentencing hearing, then I may not. So that's part of the reason I'm asking. But before you go and talk to them,
Yes, ma'am.
let me find out from counsel for defendant Wayne Greenlaw if sentencing is appropriate. What is your request?
Judge, if it's as charged, then I think the options before the court are not only limited, but they're mandatory.
Right.
And it seems to me that there's absolutely no reason why it is that we should proceed. As to any other one, well, that's not true. If the second-degree murder with a firearm is also a life or potential life sentence, but I would think that anything other than as charged, I would prefer that we have a sentencing hearing and sentence at a later date. If it's as charged, then I think we should proceed.
Counsel for Ray Greenlaw?
Yes, Your Honor. If it's as charged, first-degree murder, the court has no discretion, so I don't see any reason why we wouldn't proceed with sentencing other than the fact that we still have the possession of the firearm by convicted felon charge.
We'll deal with that
Hanging
later.
out there with Ray Greenlaw. If it's guilty of any lesser included offense, we would ask for a sentencing hearing so that we can present mitigation.
So the questions for the family are their position with regard to a sentencing, if it is as charged, and if they would want to be heard. I would defer to a later sentencing date if it's any lesser.
Yes, ma'am.
As charged, there's only one sentence. It's like, and so there's really not much to say unless you particularly want to say something in that event. It probably should be whatever you guys want to do, you have rights and we don't want to trample on. So if there's something that you want to say, then you can talk to me. But the judge would probably like a sentence made, and I believe they'll probably be as charged. That's my gut. So, we'll see. Okay. Does anybody want to say anything if it's as charged? Okay.
Judge, if it's as charged, nobody wishes to speak, let's proceed with sentencing.
All right. Is there anything else that council needs to address before, I want to address the audience for a very brief moment before I bring the jury out, but is there anything else?
No,
Mr.
ma'am.
Rhodes? Counsel for Wayne Greenlaw,
No, ma'am.
and counsel for Ray Greenlaw.
No, Your Honor.
All right, just want to make this announcement for the benefit of the audience. We started off with an instruction on how to conduct yourself during a trial, and you all have been exemplary audience members. Some of you haven't been here for all of it, but I'm sure other audience members have shared proper courtroom decorum with those that are here today. Sometimes it's hard for audience members, especially those close to the matter, to remember that when the verdict is read. I need to remind you that the courtroom decorum standards apply through the conclusion of this matter. It may be something that you are in agreement with. It may be something you're not in agreement with, but you can express your emotion one way or the other. If you feel you cannot hold that emotion in, you need to excuse yourself from the courtroom. These jurors have done a very difficult and hard job, and any distraction from their decision can be very upsetting to them. I need to also remind you, you can't say anything or lash out at them as they walk by. They will be escorted by law enforcement escort out of the building. So if you're unhappy with their decision, you can express it either in the courtroom or even if you remove yourself out of the courtroom as they pass by. I don't know that I need to say that other than to make sure that everyone is advised of it. It is part of the record, and if you are removed by law enforcement because of your reaction, you've been advised that that would be the outcome. All right, I don't think there's anything further. You may go ahead and bring in the jury.
Jury. Jury may be seated.
Everyone else may be seated. Ladies and gentlemen of the jury, has the jury elected a foreperson?
Yes.
And that is, I'm sorry, I didn't see the paper. Sir, has the jury reached a verdict in each of these cases?
Yes, we have, Your Honor.
Would you please pass the verdict forms to the bailiff? Right, the verdict forms appear to be in proper order. Madam Clerk, if you would please publish the verdicts. We'll start with the verdict as to Wayne Greenlaw in case number 2011-036-246 CFAEF.
In the Circuit Court, 7th Judicial Circuit, in and for Volusia County, Florida. State of Florida versus Wayne Greenlaw, case number 2011-36246 CFAES. Verdict: we, the jury, find the defendant Wayne Greenlaw as follows. Count 1, guilty of the charge of first-degree murder. Count 2, guilty of the charge of shooting into a building. So say we all, dated in Deland, Volusia County, Florida, this 9th day of February 2015, signed foreperson. In this would be as to Ray Greenlaw.
And just for the record, that's case number 2011-036-247 CFAEF.
In the Circuit Court, 7th Judicial Circuit, in and for Volusia County, Florida, State of Florida versus Ray Greenlaw, case number 2011-36247 CFAES. Verdict, we the jury find the defendant Ray Greenlaw as follows. Count 1, guilty of the charge of first-degree murder. Count 2, guilty of the charge of attempted manslaughter by act. If the defendant, part 2 of that question, if the defendant personally carried, display, use, or threatened to use a weapon in the course of committing a crime against Justin Riley, yes. Count 3, guilty of the charge of shooting into a building. So say we all, dated in the land of Volusia County, Florida, this 9th day of February 2015, signed Corpus.
Counsel for the state or either defendant wish for the jury to be polled.
Yes, ma'am.
All right, and Madam Clerk, if you would please poll the jury as to their verdicts.
Juror number 2, is the verdict as published your verdict as far as Wayne Greenlaw?
Yes.
Is the verdict as published your verdict as far as Ray Greenlaw?
Yes.
Juror 3, is the verdict as published your verdict as far as Wayne Greenlaw?
Yes.
Is the verdict as published your verdict as far as Ray Greenlaw?
Yes.
Juror number 4, is the verdict as published your verdict as far as Wayne Greenlaw?
Yes.
Is the verdict as published your verdict as far as Ray Greenlaw?
Yes.
Juror number 5, is the verdict as published your verdict as far as Wayne Greenlaw?
Yes.
Is the verdict as published your verdict as far as Ray Greenlaw?
Yes.
Juror number 6, is the verdict as published your verdict as far as Wayne Greenlaw?
Yes.
Is the verdict as published your verdict as far as Ray Greenlaw?
Yes.
Juror number 7, is the verdict as published your verdict as far as Wayne Greenlaw? Is the verdict as published your verdict as far as Ray Greenlaw? Juror number 9, is the verdict as published your verdict as far as Wayne Greenlaw?
Yes.
Is the verdict as published your verdict as far as Ray Greenlaw?
Yes.
Juror number 11, is the verdict as published your verdict as far as Wayne Greenlaw?
Yes.
Is the verdict as published your verdict as far as Ray Greenlaw?
Yes.
Juror number 12, is the verdict as published your verdict as far as Wayne Greenlaw?
Yes.
Is the verdict as published your verdict as far as Ray Greenlaw?
Yes.
Juror number 13, is the verdict as published your verdict as far as Wayne Greenlaw?
Yes.
Is the verdict as published your verdict as far as Ray Greenlaw?
Yes.
Juror 14, is the verdict as published your verdict as far as Wayne Greenlaw?
Yes.
Is the verdict as published your verdict as far as Ray Greenlaw?
Yes.
Juror 15, is the verdict as published your verdict as far as Wayne Greenlaw?
Yes.
Is the verdict as published your verdict as far as Ray Greenlaw?
Yes.
Jury has been polled, ma'am.
Thank you. Ladies and gentlemen of the jury, I'm going to ask you to bear with us for just a few more minutes. Based upon the verdict, it is appropriate under these circumstances to sentence the defendants at this time. I think this is important for the jury to see the outcome of their work. For your understanding, based upon your return of the verdict, the court has no discretion in the type of sentence that these defendants must be sentenced to. So there's no reason or need to delay the sentencing, and I will be sentencing them at this time. Before I do, Mr. Will, I do need some assistance on count 2 as to Ray Greenlaw, as to the effect of that verdict with the firearm enhancement.
It's not a firearm, it's just a machete, and so I'm looking now.
Okay.
It doesn't carry a minimum mandatory, but it may bump it from 15 to 30.
Okay, that's what I'm going to need.
Yes, ma'am.
And we're going to look at statute also.
I have it. Just in response to that, it's mine, I would take the position that manslaughter is a second-degree felony. Attempted manslaughter would be a third-degree felony, but then when it's enhanced with a deadly weapon, it goes back to being a second-degree felony. Which then carries a maximum of 15 years.
Correct.
And it's 78207.
Thank you.
Yes, ma'am.
All right, counsel, if you and your client for Wayne Greenlaw would please stand. Mr. Wayne Greenlaw, having been found guilty by the jury of the charge of first-degree murder, as well as shooting into a building in case number 2011-036-246 CFAES, I do now adjudge you to be guilty of each of those offenses. As to the charge of first-degree murder, pursuant to Florida Statute 782.041A1, you are sentenced to life in prison without the possibility of parole. As to count 2, shooting into a building pursuant to Florida Statute 790.19, a second-degree felony, I will adjudicate you guilty of that and sentence you to 15 years in the Florida Department of Corrections. You will receive credit for the time that you have served, and that will be noted on the sentencing forms. You will be remanded into the custody of the sheriff once we have completed this sentencing hearing. I need to advise you that you have the right to appeal. You have 30 days to file such an appeal, and if you cannot afford an attorney to represent you for the appeal, one can be appointed for you. You may be seated at this time. Counsel for defendant Ray Greenlaw, as well as Mr. Ray Greenlaw, please stand. Mr. Ray Greenlaw, having been found guilty by the jury of the charge of first-degree murder, attempted manslaughter by act, as well as shooting into a building in case number 2011-036-247 CFAES, the court does now adjudge you to be guilty of each of those offenses. Pursuant to Florida Statute 782.041 as to the charge of first-degree murder, you will be sentenced to life in the Florida Department of Corrections without the possibility of parole. As to count 2, attempted manslaughter by act, which is enhanced by use of the deadly weapon pursuant to Florida Statute 782.07, I will sentence you to 15 years in the Florida Department of Corrections. As to count 3, shooting into a building, a second-degree felony, I will sentence you to 15 years in the Florida Department of Corrections. Each of those sentences will run concurrent. You will be given credit for all of the time that you have served so far, and you do also have the right to appeal. There is 30 days in which to file an appeal. If you choose to file an appeal and you cannot afford an attorney to represent you, one can be appointed to represent you. You will be remanded into the custody of the sheriff at the conclusion of this hearing. You may be seated. Ladies and gentlemen, I wish to thank you for your time and consideration in these cases. I also wish to advise you of some very special privileges that are enjoyed by jurors. No juror can ever be required to talk about the discussions that occurred in the jury room, except by court order. For many centuries, our society has relied upon juries for consideration of difficult cases. We have recognized for hundreds of years that a jury's deliberations, discussions, and votes should remain their private affair as long as they wish it. Therefore, the law gives you the unique privilege not to speak about the jury's work. However, you are at liberty to speak with anyone about your deliberations. You are also at liberty to refuse to speak to anyone. A request to discuss either your verdict or your deliberations may come from those who are simply curious, from those who might seek to find fault with you, from the media, from the attorneys, or elsewhere. It will be up to you to decide whether or not to preserve your privacy as a juror. Deputy Murchison has all of your appropriate work and or school excuses to prove that you were in court for all the days that you have been here, as well as some other documentation. She'll also be returning your personal cell phones and other items to you. I wish to thank you for your time and consideration in this matter. You are now released from all prior instructions the court has given you regarding communication about the case, and at this time you are released. believe I announced that all sentences were concurrent as to Ray Greenlaw. If I didn't announce it as to Wayne Greenlaw, I will do so at this time. The judgment and sentence form specifically reflects concurrent sentences.
Jury.
Already took care of it.
Okay, very good.
It's all in an envelope and attached for other documentation.
Very good.
Anything else?
Okay.
Defendants will be taken into custody and we are concluded.
Oh, we do have one other thing. You started the possession of
All right.
firearm. You can do that.
Do you wish to have that reset for trial?
If they're not willing to pay, no problem.
Have you discussed that option with your client, or do you want some time to address
I
that?
would need to discuss that option with the client if they're willing to offer them time served, which is 3 years, that we could probably work it out, but otherwise, I don't see any reason why not to try it. It's easy to serve in a life sentence.
Let me do this, let me put Mr. Ray Greenlaw on the next pretrial. We can do that without notice, so that would be Tuesday, correct? Be March 3rd. Right?
Yes, ma'am.
Okay, March 3rd pretrial, you can make the decision, and you'll have an opportunity to talk between now and then as to how to address that. Well, that'll be March 3rd at 1:30.
It's okay, 1:30? And when's the trial period?
Actually, no, that would be 8:30. I've had everything on the afternoon docket because of your co-defendant and co-counsel, but since this only applies to Ray Greenlaw, well, it'll be at 8:30. March
When's the trial
3rd.
period for that?
I'm sorry.
In case we end up having to try, when's the trial period for that?
March 23rd. However, I have 3 time-certain trials that week, so I don't think it would go based upon giving the time-certain time to other individuals. It would probably be put off to the end of April. Okay? Anything further?
No, ma'am.
Great. Excuse me.
Mr. Will, do you want me to leave that other one, or do you want to sign that, or do you want to wait until after the sign it?
I'll go ahead and take care of that now.
Yes, we can go for it.
Have a seat right here. Send me Wayne. Wayne, come on. Go up that way.
That last name. No, that's it. Thank you very much.
Thanks, man, I appreciate it.
Thank you very much, I appreciate that as well.
Take care of yourself.
There, you want it? You take it.
Little twist on the dress.